All right. Welcome everyone who's just joining us. We'll start in a few minutes here. All right, folks, thanks for everyone who's joining us, and we'll get going here in a moment. I see a lot more people are piling in. Welcome, everyone. All right, let's go ahead and get started. So welcome everyone to Envisioning Law's Future, 4 New Perspectives. I'm Josh Fairfield, the William Bain Family Professor of Law at W&L University School of Law. And I research and write on the future of law, including online privacy, the next generation of cryptocurrencies, and digital property and electronic contract. In 2017, I published a book, Owned: Property, Privacy, and the New Digital Serfdom, on why we don't really own our digital assets, from Kindle ebooks to self-driving cars, and what to do about it. In a former life, I worked as a technology entrepreneur. I helped start Rosetta Stone, the language library. And you'll hear some of those thoughts on law, language, and technology on my book, Runaway Technology: Can Law Keep Up?, which I'll be discussing toward the end of this presentation. And I'm fortunate to be joined today by 3 other people who have books that have just come out or are about to come out on new, different ways to take on the question of the relationship between law and technology. From self-driving cars to robotic surgery, to COVID contact tracing, to permanently changing patterns of work and travel, to the international rules-based order, technology is transforming our physical, our emotional, our mental, and our technical and legal landscapes. To handle these problems of the future, we're going to have to do what we've always done: talk about these changes from very different perspectives, come at the problem from different angles, and work out common understandings, ways we can live together and thrive in changing circumstances. And that's what this group is. 4 different ways of coming at the problem, 4 different visions for the relationship of law to technology, centered around different problems, using different methods, and coming to different conclusions. So I'm thrilled to have with us today Professors Panmiarewa, Stacey Elvey, and Frank Pasquale to present their unique and compelling visions of how we can live together in the light of blinding technological progress. Brief note about the program. Each one of us will speak briefly and present our ideas, and then we'll have time for questions after each presentation. Please use the question and answer function to send in questions for the panelists. Although the time for questions following each presenter will be brief, we should have time at the end for a more open discussion between the panelists, and questions can be fielded by any one of us at that time. A final note, Professor Pasquale unfortunately has a scheduling conflict, and so he'll need to bow out. Please do make sure that you get his questions in so that we're able to ask him those following the end of his presentation. And so with that in mind, let's go ahead and get started. Try to keep us on time. I'm going to introduce first Professor Panmiarewa, who is the Schusterman Professor of Business and Transactional Law at Temple University Beasley School of Law. She's got so many degrees that it's hard to list them here. A master's and PhD in anthropology from the University of California, Berkeley, a JD from Harvard Law School. Her research also goes on and on and on. And this is not her only book that she's got in process right now. And so you can look in for that. So she's not content with writing the book that matters to us here, but other ones as well that she's doing at the same time. Her research focuses on technology, music, film, business, Africana studies. Prior to becoming a law professor, she served as the Foreign Service Officer in the US Department of State in Washington and Montevideo, Uruguay, and practiced law in a technology startup in Silicon Valley, New York, and Boston. And her book, which she will be presenting on for us today, and I'll hand this over to you in a moment, is Disrupting Africa, Technology, Law and Development by Cambridge University Press. So please feel free, take it away from me.
Wonderful. Thank you for that introduction, and thank you also for organizing this wonderful event today. So I'm going to talk about a segment of my book. What I'm going to talk mostly about is the EndSARS protests in Nigeria, because I think those protests to a significant degree illustrate some key themes in my book. And I just want to make sure you can, if you can't see my slides, let me know. So EndSARS is basically about governance in many respects. So my book is entitled Disrupting Africa. And basically it's about how we think about the collision between past, present, and future past.
If I could just step in for a moment. So we can't see your slides at the moment.
You can't, hold on, let me try again. I shared the right screen. Sometimes Zoom does this to me. Let me try one more time. Okay, it is the right screen. Okay, it looks like it's right now. Can you see it? Can you see the correct screen now?
That's
okay,
great.
Perfect. Okay, so my book is basically about the collision between the past, present, and future. And what I say is my focus is Nigeria. So the view in this book is basically that many African countries today sit at the crossroads of the past and potential future paths. And many of those potential future paths are embodied by various digital era technologies. So the book covers a lot of different ground. A lot of the book is historical because it's based on archival research. So I basically have spent the last 10 years doing archival research about lawmaking during colonialism in mostly Nigeria. So I've looked at colonial administration records, colonial office files, court cases, legislation, executive branch activities, the things about in relation to varied kinds of external actors. And so basically this book is it starts out by talking about governance and what I call colonial overhang. So I think in this book, in some ways, is about how we borrow law. So often as lawyers, we look to some kind of existing law when we're borrowing law in new contexts. And there are two, and I basically say in the digital era, we see two different things going on, some of which are global, some of which are specifically of issue in many countries in Africa. Globally, we're having an ongoing discussion about what I call legal and regulatory mismatch. So how do we deal with the fact that we have all these laws and regulations that were basically put in place before we had digital technologies that exist today? And it cuts across a broad range of technologies. So the question is, how do we adapt those laws for these new contexts of deployment, use of new technologies. And I think this is an ongoing discussion, and we have flare-ups from time to time. And it's an ongoing discussion everywhere. Many African countries are having exactly the same kind of discussion that we see in the United States, we see in the EU. However, in addition, in many countries in Africa, we have something that I refer to as colonial overhang. That means we have patterns of governance that reflect the colonial legacy, the colonial legal legacy of many of these countries. So the particular forms of, the particular things that I think come along with that colonial overhang. One is there are few restrictions on executive authority, because the state in many countries in Africa is the colonial state, and the colonial state didn't want to constrain itself. As a result, we have structurally executive authority in many countries in Africa that's unconstrained. You also have a dominant executive power. You have ineffective and non-representative legislative functions. That was certainly true during colonialism, and is true to some extent depending on context today. And you also have traditionally have had very limited judicial authority. I talk about that in more detail in the book. I don't have time in my 10 minutes to talk about it here. One place where we really saw during colonialism, and where we continue to see what I see as the hangover from colonial governance, is colonial petitions. So in a part of the book, I talk about what happened when people within African countries wanted to petition the colonial administration, complaining about something or saying that I need some redress. So the petitions submitted during colonialism really reflect approaches to governance that are still unfortunately evident, certainly in Nigeria. You also, the colonial government, the colonial administration was for the most part non-responsive, particularly if the person complaining was African. Now, sometimes you had a different situation if the African person was represented by someone who was English. They at least responded. The colonial administration was rarely accountable. There was a non-transparent decision-making process, some of which is transparent because I'm looking at colonial records that they probably never thought who would be looking at this 50 or 60 or even 100 years from now. They rarely responded to arguments that countered their position. So a lot of the arguments justifying the legal things that they had on the ground were incoherent at best. And all in all, in my book, I say this was a very poor basis for colonial rule. So with that as background, there are several areas where I think we see colonial governance as an issue. First of all, their networks tend to be very externalized. We see a lot of authoritarianism and lack of accountability, extraction and takings. I talk about elite formation and the power of incumbents, what I call a colonial portfolio approach, where the British colonial authorities looked at their the colonial possessions as a portfolio. So it was as if they were saying, okay, I'm going to do cocoa in Ghana and cotton and groundnuts in Nigeria. And what I argue in my book is that has profoundly distorted a lot of former colonies in that their entire economies are structured around single crops. From the British perspective, it didn't matter whether cocoa was in Nigeria or Ghana, right? Because they just wanted the cocoa. But from the perspective of the local people and local structures, it really matters what you put there at a particular point in time. A lot of countries are still producing whatever it was, whatever was allocated to them in that British portfolio approach more than 100 years ago in many instances. And that has huge implications, continuing implications today. Also, colonialism has big implications for competition, because part of colonialism at its root was anti-competitive in many respects. I talk about it in the book, but I'm not going to have time to talk about it today. Lastly, I talk about how violence was a pervasive aspect of colonialism, because and it's interesting that violence was used to promote commercial interest in many respects. So those are the key. When I talk about colonial governance, that's what I mean. So I want to move from there to talk about, we have this governance that exists in many countries in Africa. My research tends to focus on former British colonies, but I don't think it was unique in former British colonies based on the research I've done to date. I'm hoping my next project will be comparative, where I look at French, German, Spanish, and former British colonies. So Nigerians today have a lot of grievances. And many of these grievances are reflective of what I call colonial hangover. Now, these grievances include Nigeria being the poverty capital of the world. Nigeria now, in 2018, had 6 times as many people, had more people in poverty than India, even though India has 6 times as many people. There's widespread economic insecurity and high unemployment, a lot of personal insecurity and violence. I mean, people hear about the kidnappings in schools, but they're also bandits. There's risk of government forces, there are herder-farmer conflicts, there's separate insurgencies in the Northeast with Boko Haram and in the Niger Delta. There's widespread government suppression of journalists, and there's widespread corruption. In my book, I trace that all back to what I call colonial overhang with post-colonial assistance by people that have ruled after colonialism. We also see this in the midst of just a lot of new technologies, a lot of the same technologies we see here, we see in many African countries. So from mobile phones to software, biometrics, drones. In fact, I think biometrics are likely more widely used in many African countries than they are in the United States, just as an everyday identifier. In Nigeria, you can't get a SIM card without giving your fingerprint, for instance. So there's much more widespread use of biometrics. And because of colonial overhang, you don't often have the legal infrastructure relating to privacy and data security that one might need. AI, automation and robots, digital finance, blockchain and cryptocurrency. Nigeria became the second leading country in the world in terms of cryptocurrency wallets last year, partly because of government restrictions on currency. And the Nigerian government last month actually is attempting to ban cryptocurrency entirely. So we're seeing a lot of response to new technologies in ways that reflect sort of the legal process that comes out of colonial overhang, which means that people don't necessarily think about things a lot and really have a robust interchange with all interested parties before regulatory and legal decisions are made. We're also seeing genetic engineering, biotechnology, agricultural technology is a big issue all over Africa. So we're seeing these new technologies, and one place we're seeing these technologies used is in protest context. So NSARS got a lot of publicity in October, November 2020, but there are this is just some Twitter hashtags that I pulled from the internet, just in the course of like 10 or 15 minutes, you can pull these. So we see a lot of use of social media in particular as a form of commentary and protest. The top pictures from Nigeria, the bottom pictures from Uganda, which had elections in January of this year. The current ruler of Uganda has been in power for 34 years. And his being in power for that long highlights the role of external powers in supporting internal forms of corporate, I call it corporate governance actually, but we'll call it colonial overhang here. So just to give a brief summary, NSARS was a protest against a special kind of federal police unit in Nigeria that particularly targeted young people who were engaged in technology. And there's a timeline going back actually to 1992. I'm going to focus on the last 3 parts of the timeline where we have nationwide protests erupting in October in Nigeria. And these nationwide protests led to something that's called the Lekki Massacre, where Nigerian security forces shot into a crowd of peaceful protesters, killing an estimated 10 people. And the shootings were live streamed, so people saw them live, and there were numerous recordings and live witnesses to the shootings. Despite that, the government actually denied the shootings had occurred and attempted to suppress the protest. And this sort of highlights the continuing tension in the digital era. The digital era by its nature makes things more transparent because almost everyone has a mobile phone. It's certainly in Nigeria, many people have multiple mobile phones. And that's despite the fact that many Nigerians are very poor. Many Nigerians have mobile phones, and those mobile phones can be used to document things in a way that wasn't possible before. So I see the NSARS protest as partly being, bottom line, a reflection of conflicting visions of governance. We have rulers in many African countries that have been schooled in an approach to governments that reflects colonial overhang. And in fact, the First Lady of Nigeria actually called out to China as a model of governance. China's not sort of European colonial, but China is authoritarian. So there are different authoritarian models that are being used in Nigeria today. One is saying, maybe why can't we be more like China? The other is using Singapore as a source of law. But the things they're copying are very interesting. It's sort of doing a half China. Nigeria wants to do the authoritarian side of China without doing the economic reforms that have led to current Chinese economic performance. So they want to be authoritarian without the economic and other reforms that might improve living conditions for many people in Nigeria. So I'm going to end, because I know I'm out of time, by saying that part of what we're seeing in Nigeria is a battle between generations. African countries are the youngest countries in the world by far. The median age in Africa is 19.5 in 2020. African countries have the oldest rulers in the world. So you have the youngest people and the oldest rulers. And by 2100, youth in Africa will be twice Europe's entire population and close to 1/2 of youth in the world. Many of these youth are connected. They're immersed in digital technology. They understand the technology and they use it. If we think the battles we're seeing now are violent and destructive and chaotic, I think we only see potential to get worse unless we really change approaches to governance from the perspective of people who actually have power to govern, because we're going to see more and more of these protests, is my guess. Part of it is what I call scarcity of opportunity. The most important colonial overhang for many young people is they have very limited future paths for education, employment, and other fundamental things. my book says we need to disrupt that in order to offer potential for a future that's not chaotic and destructive. So I'll end there. Thank you.
Thank you so much. That was a fantastic presentation. We'll take a question now, and then we'll make sure that the rest of the questions come to the panel that we've got at the end. So for now, one question I've gotten is, do you think the increase in technology and adoption of technology will lead to an inevitability of democracy? Does there reach a point that an authoritarian power is no longer able to control a population that is well armed with technology and the knowledge of how to use it?
That's a tough one. I think not necessarily, because it really depends on how that government rules. I mean, I sort of see many potential future paths that could happen at this point in Nigeria and other countries. One is a path of continued authoritarianism that is modeled after China, where we sort of see, and in fact, many African governments are importing Chinese surveillance technologies now. So where we see in China, we've seen technology used to actually identify ethnic groups, identify and oppress ethnic groups. I could see that happening in some countries in Africa. I could see sort of technology being used for repression, which I think, given the demographics of many African countries, which are highly diverse, I'm not sure that would be very, very effective, but I think it might be very chaotic. We might see a path where technology leads to, many of the countries we're talking about in Africa are technically democratic. I would say what we would need is more governance that takes account of local people. So that takes account of local needs, that takes account of the fact that many people are poor and that they're not invisible. I think there's a level of invisibility from a policy perspective of many poor people in many African countries. And if decreasing that level of invisibility, technology can really assist in that. But I think it's going to require a combination of internal efforts, which we already have. We have many people in Nigeria fighting for internally different kinds of governance. But what I think we need to speak to is the external powers that continue to support very oppressive authoritarian governments. And I think that needs to change, because the reality is in 2100, we could have a catastrophe, even as early as 2050, given the demographics. I think the governance has to change to create more opportunities for local people, because they're getting left out of a lot of policy initiatives. And many people in Nigeria live on less than $2 a day, despite the fact that Nigeria has had tremendous oil wealth. It hasn't been deployed to support many local people there.
Fantastic. All right, and I know we've gotten some other questions. I'll make sure that those come up for us in the panel. And I'm going to move on. We'll do the next introductory section. So Professor Pasquale is a noted expert on the law of artificial intelligence, algorithms, machine learning. He's a nationally regarded scholar, and I've certainly cited him and quoted him a lot, whose work focuses on how information is used in healthcare, in health law, commerce, technology. His expertise encompasses the study of technological advances and the unintended consequences of the interaction of privacy law, intellectual property, and antitrust. He's one of the leaders of a global movement for algorithmic accountability. And in media and communication studies, he's developed a comprehensive legal analysis of barriers to and opportunities for regulation of internet platforms. His book is The New Laws of Robotics, Defending Human Expertise in the Age of AI. Go ahead, Frank.
Thank you so much, Josh. That's really, I appreciate the introduction and the chance to join such a distinguished and edifying panel. And I really look forward to reading all of the books on the panel, because it's just such exciting work being done. And so my book talk today is going to be on new laws of robotics. And in terms of thinking about these new laws, the reference point is usually Isaac Asimov, right, who sort of wrote in a 1942 science fiction story some basic laws of robotics, that robots should not harm humans, that they should be subject to human control, and that they can defend themselves to the extent that that is consistent with not harming humans or being controlled by humans. But one thing that I noted in thinking about the reception of those literary laws was how, as a science fiction writer, you can try to capture the imagination of technologists with some relatively simple principles. And so that's what I tried to do with this book, and to try to explore some relatively simple laws of robotics. I'll get into them later on, and then to see all the implications they would have. And I think that the surprise of the book to me was that in order to really keep some of the more important, I think, legal, social, economic structures of our current economy intact, current economies and societies intact, that are supportive for human welfare, it will require quite a lot of new forms of regulation and statutes and new policies about reimbursement and even new approaches to monetary policy. And I can't really get into all of that today in the sort of short time for the talk. And I deeply apologize for having a conflict with my administrative responsibilities at Brooklyn Law coming up at 3. But what I do want to do is just give a taste of some of the principles in the book and how they might apply. So one of the things I should start with is to say that the book really comes out of engagement with an automation literature. There's a very robust literature on automation of jobs. And in terms of paradigm cases of rapid automation, I have an image here of the Baxter robot, which is a classic robot, I think designed by Rodney Brooks and some of the team at MIT, that can watch what, say, an assembly line worker is doing and try to translate what the assembly line worker is doing into a series of information processors and then actuators, like the arms of the robot, to pick up things on an assembly line, put it into a box, et cetera. And I think we're going to see a lot of rapid automation continuing in manufacturing, in logistics, in mining and agriculture. Transport is one of those areas where over the 5 years that I was writing the book, when I was started, I think everyone thought that self-driving cars were just around the corner. And I think one of the case studies I look at in the first chapter of the book is to sort of look at why they haven't been in so many places. And I think one of the reasons why is because we often underestimate the degree to which new forms of automation have to enter into a social or socio-technical arena and have to garner some level of support and interest and buy-in from all manner of stakeholders, from governing entities to corporations to persons, et cetera. And that, I think, is going to be a lot of where future jobs are. That's one reason why I feel pretty confident about in training attorneys now, that there are lots of opportunities for them to really apply their skills to the incredibly difficult negotiations we're going to be making as we bring more AI and robotics into various fields. And to illuminate that, I think that in thinking about the future of particular professions, it's helpful, right? So one of the things that, you might have heard in terms of medicine is some Silicon Valley venture capitalists have said things like, boy, by 2025 or 2030, the 80% of doctors will be gone, that being a doctor really is just about pattern recognition, and it's just about having a big knowledge base, and something like IBM Watson will replace them. Well, that I disagree with. And I try to give some lasting grounds in the book. Nobody wants to write a book and then find it be obsolete, 5-10 years later. We want to write something that's going to have some lasting resonance. And so what I try to do is to explain in a more theoretical and social theoretical way why you won't see these type of rapid automation in professions, or at least you shouldn't see it. And the main reason I give for that is that medicine is in general more than pattern recognition, stimulus, and response, right? I feel that in the fields that I've just gone over, you can often simplify what's going on in those fields to pattern recognition, stimulus, and response. And in that sense, it can be translated to machines, into AI. But I think that as we look in medicine, as someone who teaches health law and policy as well, richer results from the lab, new and better forms of imaging, genetic analysis, other sources will have to be integrated into a coherent picture of the patient's state of illness. And moreover, that has to be conveyed to the patient in a way that they can understand. If you think about informed consent law in medicine and all of the implications that has. And moreover, as you try to treat somebody for whatever the ailment may be, from the least to the most severe, there also has to be buy-in by that patient to a certain treatment plan, including buy-in to when there's patient-sensitive decisions that have to be made. And this is even part of the Affordable Care Act, sort of encouraging the use of patient decision aids when, for example, someone has to decide whether to go under surgery or to have more physical therapy, say, for a back injury or something along those lines. And all of those little steps are incredibly hard to translate into machine learning algorithms, and into, even if you were to think about, very extensive libraries of videos and other things that one could go through. One of the things I found fascinating was just the reluctance of even those who have started to try to develop those sorts of libraries to allow a broader public review of them. simply because, I think they knew about their limits. And so that's why I say in the case of medicine, and admittedly, medicine is a relatively easy case for me, but I go into many other professions, going to education, journalism, policing, law, the military, many other professions and occupations are looked at in the book, that for the foreseeable future, technology complementing professionals as opposed to substituting for them is the key to advancing AI in those fields. And I go a little bit further to say that that's actually something that law should embrace. And so often law has not been embracing that. In so many areas, there are ways in which law kind of tilts toward automation or kind of tilts toward the technology provider as opposed to, say, the person who may be aided by technology. And what the book tries to do in many of those instances is to say, well, here's some doctrinal evolution and some ways of interpreting the law that would actually pull us a little bit back toward this vision of complementarity that I think is really the key to societies valuing certain labor as opposed to simply thinking of it as a cost. And that, I think, is a really important critical point here as well as we think about the law and policy of automation in the professions is law and politics, those in charge of legal institutions and politics, are actually deciding day by day which jobs, and thus which people, are going to be people who we want to help with technology, thereby making their labor more valuable, and which are the jobs and people who are deemed replaceable or deemed ultimately to be substituted by technology. And I think that really developing sort of a better theory of how to be an inclusive economy, an inclusive political economy that finds a path toward valued labor for all is really critical to my vision. And that's one reason why toward the end of the book, I have sections promoting a job guarantee as opposed to universal basic income. I think there's a place for both of them, but I think that a job guarantee to me provides more of that sort of democratization of opportunity. So in thinking about these new laws of robotics, my bottom line is that there are many, many ways in which automation has changed many aspects of life profoundly. And we're going to see, and this image is sort of meant to evoke like the Amazon vision and warehouse, where I think in so many places, in very high tech firms, there's sort of this idea of the robotics watching individuals and then eventually being able to replace them as fast as possible. But I think even in those cases, there's a social obligation to provide a path toward other types of work in these types of scenarios where automation is happening rapidly. And I saw that in some of the research I did for the book, for example, in the mining sector in Australia, sort of some pretty forward-thinking programs. Now, of course, I don't want to comment on the wisdom or lack thereof of promoting more and more and faster automation of mining of certain types of resources that could have very bad externalities. But I think, and that should be part of the overall conversation as well. But the bottom line here is that we've got to have a vision for labor that I think is more inclusive. So these 4 new laws of robotics, I've talked a lot about the first one, about complementarity and intelligence augmentation over artificial intelligence in many professions. But moreover, I think that leads in turn to 3 different laws that sort of flow from that. The second being that AI should not counterfeit humanity, that it shouldn't sort of be used in order to fool people into thinking that they're dealing with a person as opposed to a bot or robot. And that's one reason, for example, why I support California's bot disclosure law, which says that if there's like an automated bot online, that should actually disclose that it's merely a computer program as opposed to a person that is emitting those words. And I say emitting because I think that part of the challenge for lawyers and policymakers in thinking about AI is really holding on to distinctive forms of describing what the AI and robots are doing, as opposed to slipping into the language that their vendors and promoters want us to. So for example, there is a term called, care robots, but I think they ought to be called simulation of care robots, right? I don't think the care really exists there for many reasons that I give in my book. I think that this is something that's sort of a unique province of human beings. But, and so often we don't have that type of approach. And I even see it in novels, and I have a critical analysis of a novel in the final chapter where instead of calling the robot he, I call it it, because I think that we have this kind of divide between machines and persons. And if we don't maintain that divide, we're all too likely to see human beings continue to be devalued and marginalized in many aspects of labor and other policies. Finally, the last 2 laws are with respect to cooperation and responsibility. I think it's really important to emphasize the role of what type of robotics are actually adding to human productivity versus which ones are just causing us to engage in arms races where we're not actually adding to the overall stock of resources and good things in life for all people involved, goods and services for all, but instead are involved in a zero-sum arms race. And I see that actually in some even forms of legal tech. I mean, I see some people promote legal tech as a way to promote access to justice, and certainly I applaud those that are putting out, say, apps that are enabling people to dispute their evictions online. That's great to see legal tech democratize access to legal resources. But on the other hand, just as fast as that is happening, there are people who are on, say, the landlord side that are developing apps that are increasingly able to snow under tenants with demands and letters and court case dates and things like that. And so that's one where I try to deflate some of the bubble around, I think, technology as an emancipatory force, and say in the case of these arms races, which I do many case studies of in the book, that they can actually lead to everyone being worse off. And finally, responsibility and attribution. I think that any machine or AI or robotics that is out there needs to be attributed to an individual. So I just want to come back to this medical example to sort of tie it into a periodization of the types of reform that we're going to see in the future. I think that the first wave of algorithmic accountability, which I think is like an overarching concept for ensuring more just and fair robotics and AI systems, is going to be about improving accuracy, fairness, safety, and efficacy in extant and developing technology. So for example, machine learning and dermatology, that's going to lead us to demand more representative data sets so that we have, wherever there's pattern recognition, from dermatology on to radiology, pathology, other areas, but dermatology has already been written about in JAMA dermatology, other areas. We need to make sure that we have representative data sets so that it is actually advancing the healthcare of everyone and not just, say, the majority group in a particular society. Learning healthcare systems, I think, are also important here, that healthcare systems can learn from what they have done over time. And then say something like robotic surgery, that we develop ways of understanding and doing post-marketing surveillance so that we can ensure optimal cooperation between surgeons and robots. And in those areas, it really is important to note that, like, it's not the robot just doing surgery. Really, what they call robotic surgery is so often a surgeon operating a console, which has at its end a highly developed and sophisticated set of scalpels and scissor-like and other forms of actuators at the end of this being manipulated by the console. But by and large, this is something being driven by the surgeon. The second wave, I think, is going to be about questioning certain trends in health technology. And I think that, if we think about comprehensive surveillance tools, for safety purposes even, automated therapy, robot caregiving, that as well. I realize that I'm running out of time, so I just will skip to my final slide, actually, which is to say that, I want to tie this to my past book, Black Box Society, and to, note that, like, this is something that I think has been part of debates both in the US and also abroad, is thinking about how we are going to deal with the future of professions and cooperation or competition between, say, computer scientists and lawyers. And I always bridle when I see people say, well, computer science and coding is the master algorithm, in the words of Pedro Domingos. It's the thing that's going to replace everybody else. I don't think that's true. I think the ostensibly technical argument that all tasks are reducible to data patterns reproducible by machines is a political argument to put AI researchers in charge of the future development of so much of human labor. And our goal needs to be distributed expertise. And part of that is going to involve promoting productive AI rather than arms race inducing AI. That's going to create the social surplus necessary for us to actually value and invest in persons, as opposed to seeing persons as dispensable to be replaced by machines. So with that, thanks so much for the opportunity to do a quick presentation of the book, and I will stop the share. Thanks.
All right, and similarly, we'll do a question now, and then there'll be some more later. We'll kind of field them on your behalf, Frank. But the one that I thought was really interesting, based on your idea of division between humans and robots. This question says, as we master our own genetic engineering and establish corporate ownership over it, should we not be considered robots in the legal sense you have used? Should our modified descendants be considered robots and subject to these laws?
Great. And, you know, it's one of the challenges I also got on Twitter was from someone talking about cyborgs as well, right? Saying, well, you know, you might have eventually someone whose arm is replaced by a robotic arm, and then a leg, and then something else. And then, you know, your whole theoretical framework collapses if you can't do this sort of like divide. And certainly I've read some very good science fiction like Chen Qiufan's Waste Tide, which is a really interesting evocation of what that might look like. Neil Stephenson's Dodge or Fall, Dodge in Hell, which is another fascinating case study in looking at this type of potential future. But I would say in response to it that essentially, with respect to the cyborgs, there's always sort of a human mind in charge, even unless until you get into technology that's much more advanced than ours. With respect to sort of thinking of oneself as a robot because of the manipulability of, say, genetic code, this is a really profound question. And toward the end of my book, I talk about whether robots should be seen as moral patients, not even moral agents, but moral patients, say, capable of suffering harm, where, say, if someone were to drop their robotic cat or a robotic simulation of a cat and it were to cry out, then should you care or not, or something along those lines. And I say that's a really bizarre attempt to impose a moral obligation on human beings, because you could always program the cat not to, say, quote unquote, feel or simulate the pain involved. Now, the questioner has sort of tried to apply that logic to, I think, human beings, and saying that just as there could be computer code that could make the cat not express that type of expression of pain, that you could, say, eventually imagine a genetically engineered human being that would essentially be able to, say, lose a sense of pain or lose or otherwise make oneself so manipulatable. And you probably won't be surprised to know that I've also addressed some bioethics of human germline manipulation in an article called Two Concepts of Immortality on stem cell research. Admittedly, the article is 20 years old, but essentially I try to put out a number of normative reasons why we would not want to go down that path. So I'm afraid I have to refer to the questioner to my 2002 article, Two Concepts of Immortality, but happy to continue the conversation elsewhere, because it is certainly gets to the very roots of the normative framework that I'm presenting. So thanks.
Fantastic. All right, Stacey Ann. So Professor Elvey is a professor of law and the Martin Luther King Jr. Hall Research Scholar at the University of California, Davis School of Law. Her research focuses on the commercial law of privacy and its relationship to emerging technology and human rights law. Professor Elvey is a past recipient of the Otto L. Walter Distinguished Writing Award and the UC Davis CAMSA Faculty Scholar Award, in addition to the Rising Legal Star Award from the New York Law Journal. She's currently an advisor to the American Law Institute's Principles for a Data Economy Project and a contributing peer review editor for the technology law section of the online legal journal Jodwell. Her book is A Commercial Law of Privacy and Security for the Internet of Things. Take it away, Stacey.
So thank you, Josh. So before I begin my presentation, I'd like to thank Professor Fairfield, his students, and Washington Lee University School of Law for organizing and hosting today's event. So my talk, as Professor Fairfield just suggested, is based on my forthcoming book, A Commercial Law of Privacy and Security for the Internet of Things, and it will be published by Cambridge University Press this May. So the book explores the consumer implications of the Internet of Things through the lens of commercial law and privacy and security law, with a primary focus on corporate conduct. The book's arguments can really be broken down into 4 short points. So first, I argue that despite the IoT's, the Internet of Things, possible benefits, I think it disrupts our privacy across a large range of contexts. It raises significant data security concerns, and it also further enables corporate digital domination. Many existing privacy and security law frameworks, I argue, do not fully remedy these concerns. Second, I contend that various commercial law frameworks can exacerbate and further enable the privacy, information security, and digital domination concerns that the IoT raises. Commercial law provides various vehicles for the collection, transfer, and disclosure of our data, while in some cases allowing companies to shield themselves from liability. Third, I offer a comprehensive set of solutions to address deficiencies in covered sources of privacy, security, and commercial law. Fourth, the book offers several non-exhaustive reasons that in combination could explain the seeming disconnect between commercial law and privacy law and the consumer concerns of today's connected world. So in other words, I attempt to shed light on why I think these legal frameworks are inadequate. Now, all of these reasons, I argue, likely coalesce and contribute to a setting that allows many corporate actors to use commercial law frameworks to advance their interests at the expense of our privacy and security. Now, one explanation that I offer in the book is that despite the overlap of some concepts in both the commercial law and privacy law fields, privacy law and commercial law have historically focused primarily on addressing a distinct set of questions. So what do I mean by this? Unlike privacy law discourse, which has predominantly explored questions and claims related to knowledge and access and the use of information about us, commercial law has long had a heavy focus on issues relating to trade involving individuals, merchants, and entities, and also a very heavy focus on the transfer of rights in various forms of assets. However, privacy and commercial law are increasingly, I argue, overlapping in today's connected world. This melding of the privacy law and commercial law worlds obviously predates the Internet of Things, but I think the IoT exacerbates the concerns that arise from privacy laws and commercial laws' inadequate recognition and resolution of the issues that are caused by this growing overlap. Now, another reason that I offer in the book to explain this disconnect, again, is that despite what appears to be distinct inquiries, both commercial law and privacy law historically reflect varying levels of deference to or respect for corporate practices. Now, this deference, I argue, has likely contributed to an environment that allows some corporate actors to use both bodies of law to better or to best serve their interests. So in the privacy context, this deference to corporate or commercial practices has taken the form of a self-regulatory approach to data privacy and notice and choice, right? So as we all know, notice and choice has historically dominated our approach, the US's approach to consumer data protection. And oftentimes powerful tech companies have played a significant role in hindering or blocking proposed consumer privacy and security laws while advocating for more notice and choice or for more self-regulation. So the privacy notice and choice regime, though, has to some extent also been duplicated in commercial law as well. So the perfect example of this that I talk about in the book are the 2005 amendments to the Bankruptcy Code. Now, outside of privacy law's influence, commercial law on its own has for some time displayed a high regard for the development of commercial practices as well. So this respect for business customs and commercial practices, I think it goes, or it appears to go beyond a mere recognition that commercial practices are going to evolve over time. So deference to commercial practices is evidenced by the text of the UCC, the Uniform Commercial Code, which is a core source of commercial law here in the US. So for instance, Article 1 of the UCC provides that one of its core purposes, right, one of the core purposes of the code is to, quote, permit the continued expansion of commercial practices. And so given that one of the underlying purposes of the UCC is to facilitate the expansion of commercial practices, the development of modern day commercial practices involving data trade arrangements and the potential applicability of the code, the UCC, to those types of transactions is in keeping with this goal. Now, this esteemed view of commercial practices combined with the role that corporate advocates play in the UCC revision processes and the UCC's goal of uniformity could explain why the UCC has not yet been fully revised to more adequately reflect and deal with consumer issues. Now, although there are currently several provisions in the UCC that directly address consumers, the UCC, the Uniform Commercial Code, has been, I think, significantly unwelcoming to consumer protection issues. Commercial law frameworks have oftentimes struggled to address consumer concerns, and attempts to adapt various sources of commercial law to deal with technological developments have, in notable cases, been either unsuccessful or partially ineffective. And the examples I give in the book are the 2005 amendment to the Bankruptcy Code and the failed Article 2B of the UCC project, which resulted essentially with, resulted in UCITA. So today there is an ever increasing blurring of the lines that separate the privacy and security law world and the commercial law world. So the rise of the computer, modern day databases, big data, companies' free and freemium data business models, and various other newer business models and programs, so pay for privacy, personal data economy, et cetera, right? And now obviously the Internet of Things, they have all created an ever increasing overlap between privacy and security law and commercial law. So I argue that these business and technological developments have pushed us deeper into the realm of what I call the commercial law of privacy and security. And so the result is that our concerns about privacy and security, I argue, are intricately connected to the commercial law frameworks that can allow companies to exploit our data. So in today's connected world, our concerns about, quote, who should know us and how are determined by the privacy law and the commercial law frameworks that govern consent and firms' data collection, monetization, transfer, and disclosure practices. So commercial law, and in some cases, other corporate law frameworks are directly implicated by the pressing privacy and data security concerns of the Internet of Things era. So some of the questions I explore in the book include how the law and our society should respond to and evaluate, for instance, the proliferation of the IoT and firms-related implementation of business models and various programs and their product design and data practice that in combination work to continuously surveil our activities. I also look at the extent to which existing commercial law and privacy law frameworks should be adjusted or can be adjusted to adequately remedy privacy and security concerns. I also turn to looking at the issue of consent, right? Consumer consent to companies' data practices, including transactions that are potentially subject to Article 2 of the Uniform Commercial Code and the implications of that consent. I also consider in the book a company's use of asset collection technology and IoT devices to digitally dominate and restrain our activities and lending transactions, including those transactions that are also potentially subject to the Uniform Commercial Code as well, Article 9 in particular. Another topic I cover is also companies' possible use of our data and the rights associated with these data and secured financing transactions that are potentially subject to the UCC as well. And then lastly, as I alluded to earlier, I also cover businesses' disclosure and transfer of our data in bankruptcy proceedings. So as I mentioned earlier, the world of commercial law and the world of privacy law are now, as I see it, inescapably linked in a marriage of sorts. In commercial law, can serve as a crucial source of corporate power. So it's commercial law, for instance, that gives teeth to privacy laws and notice and choice framework, right? So it is commercial law's inability to sufficiently grapple with privacy and security issues that has allowed companies to, in some cases, exploit privacy law's heavy dependence on the notice and choice regime to extract what appears to be almost limitless rights from our data, and has, in some cases, blessed corporate data practices. It's contract law and the lending frameworks of commercial law, I argue, that allow corporate actors to use IoT devices and various other technological developments to extend their domination over us in various transactions. And similarly, it is products liability laws and the UCC's inability to account for the interconnected nature of IoT devices, services, software, and systems, as well as other technological developments that allows many companies to be free from various forms of liability for privacy, security, device failures, and digital domination harms. Similarly, it's the UCC, the Bankruptcy Code, and other sources of law that enable firms to opaquely and easily transfer and monetize our data in corporate transactions, right, which oftentimes leads to them being able to solidify their market power and also to consolidate our data. And this is occurring primarily to advance their interests. So as I discussed earlier, many of the privacy and security harms I think that the Internet of Things raises lie at the unique intersection of privacy and security law and the commercial law world. So what I call the commercial law of privacy and security. So what can we do about this? The book offers really a two-pronged, comprehensive approach to address inadequacies found in various sources of privacy and security law and commercial law, and to better account for this increasing overlap between commercial law and privacy and security law, right? And in particular, the privacy and security concerns of today's connected era. So first, I argue that the lack of a comprehensive privacy legislation at the federal level in this country, in the US, has made us to some extent an outlier when you compare us to regulatory approaches in different parts of the world. So the book joins earlier calls or earlier recommendations in support of relying on some aspects of the European data privacy and security approach in reformulating our approach to privacy. I also argue that some provisions from other domestic frameworks can be useful sources as well. So federal legislation can shed light on permissible data practices and impose prohibitions on certain data-related activities. A comprehensive baseline privacy and information security federal statute that does more than just mandate notice and choice, and that establishes the contours of acceptable and unacceptable data practices, I think could be a key step in better safeguarding our interests. So as we know, the FTC, the US Government Accountability Office, some academics, consumer advocates, and others have long recommended that Congress adopt various versions of a comprehensive federal privacy and security statute to better protect consumer interests. So there are several GDPR and CCPA-like rights that I cover in the book, as well as legal obligations that could be incorporated into federal baseline legislation. Federal legislation could also explicitly require rather than recommend data minimization and privacy and security by design and default. And I think privacy by design in the IoT setting should to some extent mean that strong privacy settings are implemented by default and devices are designed to function without always having to connect to the internet and collect and transmit data to third parties, right? Or even potentially directly to the company, right? Depending on the type of device. So as I mentioned earlier, I argue that a comprehensive two-pronged approach can help to better reconcile provisions in commercial law and privacy law frameworks that can enable various consumer harms. So in addition to joining earlier calls for the adoption of baseline privacy and security legislation, I also propose revisions to important sources of law governing commercial activity. I mentioned the UCC, the Uniform Commercial Code, the Bankruptcy Code, and products liability law as well. So to conclude, the volume and types of data, I think, about us that are now more readily or now more easily available to companies has increased significantly. So what does the Internet of Things mean for us as individuals and for us as consumers? The book seeks to answer this question by highlighting the different ways in which commercial law impacts the privacy and security issues of today's connected era. And the book offers a two-pronged comprehensive approach to usher in a more robust commercial law of privacy and security that can better protect all of our interests. So I'll stop there and I look forward to comments and questions. Thank you.
Wonderful. Well, so here's one that's directly down, I've read the book and I think I've read manuscripts of the book and I think it's wonderful. And so this one's gonna be right down your alley. So when you were discussing the notice and choice regime and sort of the tension between commercial law and contract law, the question is, it seems that the law in this area has heavily favored IoT sellers through end user license agreements and terms of service. What would you suggest would shift that power dynamic? Is this a job for legislatures or courts? What does commercial law do to permit consumers to push back on contract law?
So thank you for that question. So one thing that I talk about in the book, and I alluded to a little bit in my talk today, is to correct this heavy reliance on notice and choice, right? And so oftentimes I think what happens is even if consumers may have specific rights under a consumer protection statute, right, with a click of a pen or a click of the I agree button, you can oftentimes consent to many things, and ULAs are one such thing. I think the concern in the IoT setting as well is what I call contract distancing, where you have all of these devices that don't actually have screens, right? So typically, well, pre the IoT era, oftentimes we're accessing the internet on our phones, our laptops, and our tablets, right? And now I think that's changed significantly, where we can access the internet essentially through a lot of these devices that don't have screens, right? Well, so why do we care about the screens? Because oftentimes the screens are used to disclose companies' privacy policies and terms of service, right? And so if you're potentially contracting through a device and entering into an agreement, right, through a device that actually doesn't have the ability to display the terms, can we really view that as meaningful assent or consent, right? And so I think that we need action on both the legislative front, but also for courts to think, I think, more to think deeply about and to potentially address this contract distancing issue. And there's a lot of empirical research as well that suggests that individuals don't necessarily understand, aren't necessarily reading the terms and conditions or privacy policies that companies offer. And that also raises the question of whether they actually understand the implications of consenting and what that means down the line for their privacy as well. So I think there's room for both courts and the legislative branch to tackle these issues.
Great. And I'll also just read off a comment that just came in from a good friend of mine, and looks like they know you as well. Hi, Stacey Ann. Your view of the relationship between privacy law and commercial law is spot on. Unfortunately, those who were involved in UCC revisions in the 1990s are still scared off by what they all describe as the UCITA wars. I hope you participate in the current discussions of the drafting committee on the UCC and emerging technologies. We need more voices like yours in the committee discussions. So the invitation is open to everyone who writes about these topics. So I just saw that come in and wanted to pass it on there as well. All right. All right, then we will pass on to my presentation, and then we will take a grouping of the discussion points, the questions that have been raised so far, and we'll discuss it among those of us on the panel. So for me, I'm going to now get my screen right. I have, there we go. And share screen, and my computer is a little bit odd, so if people can nod if they do see the right thing, that would be fantastic. All right, you all able to see this? Fantastic. Okay, so my first point, the book is called Runaway Technology, Can Law Keep Up? And it addresses a narrative that we're all familiar with. Anybody who's looked at technology has heard this story, that technology is fast, law is slow. And that's what I want to address. Because if you have kept track of the regulation of technology over the years, you've noticed a pattern. Take Napster, for example. There was a claim that the advent of the internet caused copyright law to fall apart. And it didn't happen. Napster got sued out of business by those who raised intellectual property claims. Or the owners and creators of virtual worlds charged that they said a magic circle separates the real world from our game world. And what happens in the game world stays in the game world, such that if fraud is fun in EVE Online and you're defrauding people, then we can hedge out real world law. Only it didn't really happen that way. Or Bitcoin regulation. We've heard the ideas that Bitcoin now has done away with the need for basic banking regulations, things like the Bank Secrecy Act, anti-money laundering, know your customer requirements, and that Bitcoin was going to free us from the bank's stranglehold on crypto, on finance. And that didn't work out that way. In fact, law responded incredibly quickly. Within 18 months, we had not just regulatory regimes for anti-money laundering and know your customer, but we had them further for commodities exchange and for securities regulation and so on and so forth. And now we're seeing a similar story about, for example, privacy and intrusion through Google's stranglehold on Android, or similar movements to gather information from Internet of Things devices. And the claim again is that law can't keep up with technology, that what's going to happen is technology is going to run away with all of us. All right. The point here is that that is simply propaganda. You'll notice that in these arguments about law not being able to keep up with technology or technology being neutral, it's never the right time for law to step in. It's either too early, and that's a claim worth asking about, because if law can't keep up with technology, then where do we get this idea that law is often there already in place before the technology is developed? And here I'll use an example that struck me. My younger brother, who at the time was one of the engineers for the Google autonomous car project, now works for Waymo, and I think he's actually on the call, was thinking about an asteroid mining company that was using drone robotics. But I got interested in the question of what would the law be of capturing and mining asteroids. And for anybody who's taught a property course, we teach a case called Pearson versus Post, which is the person who captures the asset first, takes it. And that more or less is going to be the law we expect to govern asteroid mining. The person who touches it first, who conveys information about it first, they're the one that's going to take it. That is, law creates stories. Those stories extend by analogy to new cases naturally. It's a rare case when new technology creates a circumstance that law has not already told a story that humans think extends to that case. For example, if we have a case of murder that is not by sword or by gun or by lightsaber or by laser pistol, but is instead by hacking somebody's pacemaker, no one is going to say, oh, that's not murder. Law is going to extend naturally and immediately to those cases. All right. Law can keep up with technology because law is technology. It's a social technology. It's built by humans out of cooperative fictions, things like 2 o'clock, the time Eastern Standard when we gathered for this conversation. Money, nation states. These cooperative fictions we create out of language together. We talk together and we develop these things that let us upgrade our ability to cooperate in community. That cooperative faculty is our superpower as humans. It's the reason that we, and not say wolves, run this particular show. If you look back over our history, our ability to develop these cooperative fictions, as Yuval Harari and others call them, and then to develop them at speed is the way that we have always addressed changes in our technological framework. So if you think about, for example, ants, right? Ants and bees do fit what noted entomologist, that's bug guy, E.O. Wilson calls that they are eusocial species. They're species that cooperate at massive scale, over say just a couple of hundred individuals into the hundreds of thousands or the million scale. And ants cooperate this way, bees cooperate this way through genetically evolved behavior in geologic time, in very slow time. However, humans are super cooperators, not necessarily because we're better at cooperating. We're different from the other 2 eusocial species that Wilson points out. We do cooperate in our hundreds of millions, but we don't do it by evolved behavior. We do it by this shared capacity, language, that we use to develop new forms of meaning, new ways that we can cooperate together, new symbols that we can gather around. And it's not our ability, we're not any nicer than bees or ants, but what we can do is through language, we learn to cooperate at historical speed, right? So if ants and bees have a problem, they run into this is Yuval Harari's quote again, if they run into a new opportunity or a new threat, they don't get to guillotine the queen and declare a republic. We can make up consensual hallucinations, things like republics, things like democracies, and give those words meaning as a way of cooperatively adapting to new circumstances as they arise. What that means is that we're going to have to re-envision law. So many of us might think of law as rules contained in old, dusty law books. We might point to, for example, examples of laws. There's one that says that you can't wear a suit of armor or carry a sword in the UK Parliament. Or in some towns, you have to carry a lantern in front of your horseless carriage. And those, in order to not frighten the other horses, those laws are still on the books. Or we might say, for example, look at the Stored Communications Act, which was built, it's the modern framework for government access to your emails. And it was built at a time when people were deleting their emails off of common servers after they had read them. Those laws we point to as obsolete, but it doesn't make sense to say law can't keep up because we want law to be like a coral reef. Sure, there's the massive dead part that doesn't matter, but then there's the living edge of it, the new rules that we're developing together that do govern these new cases. And what we notice is that law bubbles up between us. So every time we come up with new technology, you'll notice that humans have ideas about how it ought to be applied. Maybe somebody tells their children, put the smartphone away at the dinner table. But maybe it's also, for example, we could talk about the evolution of Google Glass. And when Google Glass first came out, one of the real pushbacks to it was largely social, that people deemed these people, and excuse the expression, they deemed the wearers of glass holes, and there were almost physical, there were in some cases, physical responses to the use of that technology in space. If we think of law as what bubbles up between us, as the negotiated social technologies, the norms that we work out between us, rather than top-down rules established from above and that trickle down by legislation legislatures and handed down by judges. We can see that law by analogy, that idea that a murder is a murder, whether it's done by a sword or pacemaker hack, can help us regulate most uses of technology as soon or even before they really become widespread. But how do we move this into the future? Well, we need to be able to develop better cooperative fictions. And here I'll just turn to, I'll point to a lot of the hashtags, for example, that Professor Panmiarewa pointed out were used to gather people to deal with a novel circumstance. And they gathered these hashtags became new cooperative fictions, new locuses, new places for people to gather around. And the question is, can we get even better? Newer cooperative fictions to handle the problem of the future by doubling down on how we create language. And the book establishes a few ways of doing that. The one thing is we think in groups. We think in groups by developing language together. And the kind of groups that Scott Page and others work demonstrate develop new language, new symbols, pick the hashtag that comes to your mind right now that has helped us navigate the last year, for example, that's helped us coordinate the last year, that's come to mean something that it didn't mean before. And what we want are groups that have shared goals, but radically different approaches to the problem. What that does is that helps us deal with things that I think we've all noticed in the past years and in the past year, things like my side bias, where we each passionately express, but also overcommit to ideas that we hold true ourselves. And what you'll notice is that although we are systematically often wrong, our passionate advocacy for these ideas helps a group better rate, get a full vetting of these ideas, and that a group can often come to better decision-making through this individual assertion of ideas that may well seem biased or otherwise logically incorrect when held by individuals. That is, groups like this one, right, where we've got people coming at the ideas of how law can interact with technology in different ways, coming from different angles. We've got different viewpoints expressed, and then we've got you who've joined us here who are asking questions and testing this. What we're doing is we're creating a conversation together. The words and the phrases that we draw out of it then will join the rest of the cooperative symbols we've developed, will become a way of talking about it. You can refer to this as the things we talked about at Envisioning Law's Future, and those ideas then become cooperative symbols around which we can rally or challenge in order for us to address the problems of the future. And with that in mind, I've come to my 10 minutes, and I will also scan my own questions, and I will take one. But then I think what we should be doing is moving into our question and answer period here. So let's see here. I've got one here. Even if changes in law and politics are equipped to regulate and shape technological practices in a good manner, is it even possible to enact these changes given the pervasiveness of regulatory and political capture by many of the largest technology firms? If many of these firms can wield influence over both government and people themselves through mechanisms like social contagion, how is it possible to enact substantive change without frustration of those efforts by or fear of reprisal from those firms who those changes will harm? But that's a great question, obviously, since I picked it. There are real issues here, and sort of there's two. There's one, there's just simply a question of power. The description that what I'm describing here is a way to let the consensus about how we ought to live together to deal with the problems of the future bubble up from human suggestions about what works. So, for example, if we decide that if you've ever been to Chicago during a blizzard, you'll notice that people shovel their own spots in the blizzard. And if you park in somebody else's space, you really get in trouble, right? That's a social rule for living together that's been developed by the people. And what happens then when there's a grab at the top level that pushes back on it? I think what we can do, mining companies the world over, for example, are beginning to talk about things like the social license to operate. What they noticed was, even though it's perfectly legal for them to operate, they're running their mining groups, that local communities who now have a voice and have begun to push back have revoked their social license to operate, have said, no, we won't stand for this. I think that we can call for and expect a reinvigoration of outrage around, for example, the privacy practices that that Professor Elvey was talking about, or the social nodes that Professor Arewa was talking about. Right, that outrage can be reinvigorated, can be recreated, and we can further detail the social license to operate in a way that, even though it's not written into law codes, it really does functionally push back on how people, on the ability of these companies to operate. And so we see that, for example, Facebook was not largely constrained by law in the most recent year. Facebook was largely constrained by growing outrage as to its practices with data over WhatsApp and so on, or its promotion of extremist content through its engagement algorithms, that it was social pressure and the sense that they had exceeded their social license to operate that caused that retrenchment. We need to see that as law, as the living edge of the law, the place where we're developing it, because only that kind of legal development is going to be able to keep pace with technology. All right, we've got then I think about 15 minutes for a range of other questions, and I'm going to gather a selection here. We've been sort of putting together a bunch and putting them into a document, and I'm going to farm these out. Thank you for those of you who've stayed here for the last few minutes, and we will parse these out, and then we will end in 15 minutes. So let me pull the first here. For Professor Elvey, do you believe more lobbying power is needed to accomplish comprehensive privacy regulation? Who are the most influential pro-privacy groups today?
Okay, so I do think it'll be helpful to have more lobbying power. There's, obviously significant lobbying efforts on the part of tech companies. In terms of leading privacy organizations, I think there are a lot. There's the EFF, Greenlighting Institute, EPIC, Privacy Rights Clearinghouse. I think there are a lot of organizations out there who are attempting to advocate for individuals' privacy rights.
All right, let me pull up some more here. And let's see, I've got one that I received here. Up, which is, does section 230 need to be changed? If so, how so? So for those of you who are on the call, and I think any one of us, all three of us can weigh in on that, and I'll ask maybe Professor Elvey if you want to start. Section 230 is the law on the internet that says that companies are not responsible for the actions of their users. For example, if I were to say something defamatory on this call, that Zoom would not be liable for the things that I said. And Professor Elvey, would you want to take a crack at that, and then I'll follow it as well?
Sure. So I cover section 230 of the CDA in the book, and particularly the aspect that I focus on is the connection between the CDA and products liability law. So there are several cases that have found in instances where you have individuals and oftentimes either consumers and they may be let's say they purchase something on Amazon, a device, and it's somehow defective or maybe caused injury in some manner. So there's, in the products liability context, one of the things that you'll see addressed is whether or not a company such as Amazon is in fact the seller of the product or qualifies as a seller, as that term is defined under the applicable products liability statute, right? And so even if you jump over that hurdle, because sometimes Amazon doesn't actually, as we know, sell the product directly to us, right? As individuals, they simply just do the packaging and the shipping. So the device might have been sold directly by a third-party seller. So there's that potential issue as well. So even after you potentially jump over that hurdle, if you do, there's also the problem with the CDA, which can essentially immunize or deflate the power of any sort of products liability claim, right? And so to the extent that Amazon, and this is connected to, for instance, the the description that's given for the product, right? The CDA can immunize platform companies from products liability claims to the extent that it applies. So there's that portion of the CDA that I talk about in the book. And I think that with respect to platform companies, I think that one of the things that we could do is perhaps carve out products liability claims from the CDA's application.
Actually, you've got most of what I was going to say as well. I think I'll add to it. And the CDA is a really complicated issue right now because you've got people saying, one, the CDA is why Facebook is censoring me. On the other hand, you've got people saying, no, the CDA 230 is why Facebook has let things get to this pass. And I think that in a way, revision of the CDA is so complicated because we can't unwind the history that got us here, the degree to which companies built these entire models of monetizing outrage by not being responsible for the statements that were put out. And so if we're going to revise it, it's going to have to put a finger on that pulse, both that the CDA does now permit censorship, but also it created the need for it by making these internet backbone companies not liable and therefore largely ambivalent about the kinds of things that their algorithms were promoting. All right, I've got a question here for Professor Arewa. Do you think that a new, presumably younger administration would be more cognizant of the economic growth potential of a more liberal policy regarding emerging technologies, or likely to continue the same way? I think you're still muted, Professor Arewa.
Sorry, I muted myself. I think that raises interesting questions. I think there's a theme in our last few responses about power that we need to think about a lot when we think about law, because we often tend to think about technology as being neutral. We tend to think about law as being neutral, but they actually, I think as Professor Fairfield really laid out very nicely in his presentation, they really are parts of context that are imbued by all kinds of power relationships. And also ways we use language to present a certain understanding of law that may or may not be accurate. I mean, one of the things that's really interesting if we look in African context, it's pretty clear during colonialism, the people that were advocating certain adoption of certain kinds of laws did not really entirely understand how the law actually worked, because they were taking a very top-down approach and they didn't necessarily understand how it really worked on the ground. And I think there are a lot of different things to think about when we think about, well, would a younger person be better? One of the things I talk about in my book that I think is relevant to technology companies is that one thing that happened during colonialism, and it has to do with how elites were used as intermediaries during colonialism, because there were very few people on the ground during colonialism. So local elites came to be a key intermediary force. And there was a problem with different jurisdictions because we had customary law, we had English law, and a lot of elites, not all, but a fair number of elites came to engage in what I call jurisdictional arbitrage. So they looked at the two different systems and said, well, how can I profit from arbitraging between the old system or the system that was here when the British came and the system that the British are introducing. And so you put in place in many societies in Africa an incentive to profit from their own societies. And I think the problem is that hasn't gone away. You actually see sometimes reinforcement of it. And I think that's a powerful impediment to, if you have that younger ruler, I see three potential paths. One, that younger ruler could say, I'm going to arbitrage too, which is a strong possibility. That ruler could actually understand technology better than the many older rulers we have now, and they could use it to be even more oppressive. Or they could actually take an approach that I might advocate that would say, let's use technology to move to figure out how to create better opportunities for the entire society. So I think I don't have the answer. I'm sometimes scared about some of the potential paths that could be followed. And I think I would add this arbitrage thing to our discussion of technology companies, because one of the things they've done very well, I entirely agree with Professor Fairfield. I call it legal and regulatory mismatch, in that the laws that when adopted don't necessarily fit 100% the new context that we find them in. Technology companies arbitrage those differences. They look at what the law says and figure out, how can I make a profit given that this is what the law says on the ground? And this says at least in black and white. And this can be a problem when we want to change things, because I think Professor Fairfield, has issued a powerful call that I agree with. We need to think about, how do we innovate in law? because I think a lot of our existing approaches in law make assumptions about how law works, and they don't necessarily take account of law in black and white versus law on the ground as to how it actually works, and how people use techniques and strategies like arbitrage to benefit from those differences. I think we have to be very attentive to uses of power, especially since technology companies today have unparalleled power. I think I've been watching with great interest the Facebook Australia face-off, where Facebook basically decided to shut down an entire country. If Apple were a country, it would be one of the 10 wealthiest countries in the world. So we have tremendous power aggregated in technology companies that, because of the way that the technology sector works in the digital economy, they control a lot of things just by shutting off. I mean, Facebook can shut off a country all at once. I don't think anyone 10 or 20 years ago would have thought, most pre-technology companies couldn't have really had the same impact, I think, in shutting down a country. So I think we need to think about arbitrage and power, legal innovation, and understandings of the law. Because I think, and this happens more when a US expert goes out to Africa to give advice, sometimes they don't really think about, does the law really work as I think it does here? Because often it doesn't. And so we're in the process, we're talking about this legal debate in the United States about, does 230 work? People advocate all kinds of things when they go outside of the United States, even though these things don't really work or are incredibly problematic in US context. So I think that's something we should think about as we think about how do we innovate law for this future that's going to be very technologically driven.
Yeah, I mean, and I've gotten another question here that I think is going to follow up, and it'll be sort of for all three of us, just because, I think you've identified something here, the centrality of difficulties about power dynamics at the heart of law and power asymmetries at the heart of law. So here's the question. Can law or regulation, can it effectively serve to balance out the power dynamic between a corporate service provider and the consumer, wherein the one-way demand in terms of service or contract require the consumer to waive essentially all rights of action, or then in these other contexts we've been talking about? That is, what's the extent to which, we've talked about the ways in which law embodies power dynamics. What are there ways that we can systematize law serving as a stop against or providing the space to innovate in the face of these power dynamics?
I just have a one-sentence answer. It depends on who's making the laws. It depends on who's making the laws. And I have, when I sat and listened to the congressional Facebook hearings, where it's very clear that many of the people making the laws, I don't think understand the technologies. I'm not necessarily an optimist, because I think between regulatory capture, capture of legislature, and lack maybe of understanding, I think we're gonna have to work really hard to get to where we might need to be.
So I would say that I think there's certainly room for the law to play a role in attempting to level the playing field to some extent between corporations and consumers, particularly in the IoT space and just dealing with technological developments in general. I think that's a role that the law has long played. And if you look at the various consumer protection statutes, right? The goal being to better protect consumer interests. And but as was just noted, I think there's certainly concerns about the language that would potentially end up in any resulting legislation, and whether or not the individuals drafting legislation particularly understand the technology and particularly understand the concerns that are being raised by some of the new technologies that we're seeing coming into play. But I do think, I take a somewhat of a positive view again in saying that I do think that there's a significant role that the law can play in evening the playing field to some extent, and at the very least attempt to address some of the consumer concerns that we're seeing.
And I would say, I'll sort of bookend Professor Arewa's point, which is that if we're looking for law from the halls of power, then we're going to expect laws that are sort of tainted with this asymmetry. I do think that we've noticed in the past year and years that there is power in language from below. That when we can change the terms of debate, that when we do change the terms of debate, suddenly all of these impossible statements become untrue. And I'm just thinking, suddenly just flashed through my mind for whatever reason. The idea of what was the moment at which a country like East Germany, which had profound which had profound, of course, complete control over its citizens, suddenly shimmered, wavered, and disappeared. And it was a moment, this may sound a little bit like kind of revolutionary fervor, but it was the moment at which a bunch of people showed up at the border, the quote goes, and asked one person, hey, may we pass? And the answer to that turned out to be, yeah. That is, I do think, when I go to conferences on, Professor Elvey, we kind of end up at some of the same stuff a lot on privacy and commercial law. Like, there's this sense that people are waiting for the other shoe to drop. There is this sense of kind of a rising surge of dissatisfaction with how the law is. And I do think that we have the possibility for these moments where these power dynamics at the top level seem intractable, that the people involved are entrenched and may not understand the technology, or maybe regulating but not for the citizens in general. But yet there are these moments when you can sort of see a whole paradigm kind of waver, shift, and then vanish. And I don't think that these assumptions are invulnerable. And I'll say this, that's why the law can't keep up with technology propaganda is so strong, because there is this real sense that it can, right? That please don't regulate, please don't regulate, please don't regulate, gets said with such fervor because it's possible. And so I do have a slightly hopeful take on that. All right, let's, since we got to get people out of here on time, then what can we do to help? What can a concerned citizen do today to amplify their voice and have have an impact in shaping the policies and regulations that might constrain some of the worst excesses of future influence over technology and private law? Can we do more than just, then this person says, can we do more than just make a donation to the Electronic Frontier Foundation? What should people take away from this? What can they do?
Well, I'd say that, now we have obviously, I think, more states becoming more active on the legislative front and in dealing with privacy and security issues. So the CCPA and now CPRA since November. And then obviously, I think a couple of weeks ago, another state, I believe it's Virginia, right, that passed their own version of a comprehensive privacy law. So, I think that one of the things that we can do in terms of, depending obviously on the state that one lives in, right? So if you have laws that are granting you specific privacy rights, so the right to opt out of data sharing for behavioral advertising purposes, or the right to opt out of data sales, I think, attempting to just on an individual front engage with privacy disclosures and attempting to potentially exercise those rights, I think is one thing that we could do just on an individual basis to attempt to better protect our own privacy. Again, this is not, I think, a perfect solution, right, in the sense that it then places the onus on the individual to do a lot of the work. And so this is one of the reasons that I think that we need a legislative change at the moment in this space, because the self-regulatory approach to privacy and notice and choice, I don't think that it's getting us where we are heavily depending on notice and choice is getting us where we need to be in light of the new technological challenges that we're facing today.
And Professor Arewa, what do we do?
I would agree. I think we need a combination of different things. I think, first of all, individuals do have a role to play. And I think individuals could also make more conscious choices in what products they use. So if people really don't like Facebook, if they shouldn't use it. That may not be a solution for many people, but I think a lot of people, we talk about privacy, but sometimes our own practices don't reflect that we value privacy as much as we should. So taking advantage and individually opting out as well. I think there's also a role for law in this, and how thinking about strategies for getting to the right place. I was really struck by, this doesn't relate to privacy, but I was really struck by the difference between the Uber Lyft campaign for Proposition 22 in California, where they basically managed to effectively overturn legislation, basically saying that Uber drivers were employees, versus what's going on in the UK, where Uber has now said we're going to call them workers because the UK court said that your position is incorrect. So I think we can learn from that experience of regulation, because there's no reason we can't regulate some of these companies in a similar way in the US. It likely would be at the state level, given the structure of how our legal system works. But I think if we have the initiative and we have the resolution, we can at least start to move in that direction.
And I'll close since we're at time, by saying that I think the thing that people can do most is this, is engage and have hope that we can work out between us ways to live together given this technology. Where we are now is not inevitable. It's a decision, and it's a decision that's been made by people who don't always have our best interests at heart. That conversation can change as we engage with it and as we develop language to talk about it, to call out the practices that harm us and describe the world that we want to live in more cleanly. And the stronger that language can be, the cleaner that language can be, the more that we can gather and rally around it and learn how to work together. So with that in mind, we're at time, and I'm a former appellate lawyer, which means when the red light goes on, I stop. So I'll let people go. Thank you so much for having been here, for those of you who made it to the end. And thank you so much to Professor Pasquale, who had to leave us, to Professor Elvey and Professor Arewa for joining me today. This has been a wonderful conversation, and I look forward to continuing these conversations offline and with all of you who've been here today. I know we didn't get to everybody's questions, but please feel free. I know all of us are very interested in continuing the conversation, so please feel free to contact us to send further questions, especially once and as soon as you've read these excellent books that are coming out. All right. Thank you all so much, everyone, and we'll end it here. Thank you all. Take care.